Good afternoon, everyone. Welcome to our webinar for managing accommodations and leaves. We're going to get started here in a few minutes, but just a couple housekeeping items. First of all, if you have any questions during the presentation, if you'll type in your question using the Q&A section on the webinar. Another thing is that we have gotten approved CLE credit for the state of Colorado, which I think can be transferred to other states, and we've also gotten approved credit from SHRM for 1 credit each. As we go along, if you just want to make sure your lines are muted, that way we'll be able to have good audio for the whole presentation. And again, if you have any questions, just type them in the Q&A section. Thanks so much, and we'll get started.
Good afternoon, everyone. This is Mark Waletsky, and I am here with my colleague Steve Gutierrez from Holland & Hart and Megan Holstein from the Reed Group. And we first just want to welcome everyone to this webinar on top tips for managing difficult leaves and accommodations. Steve and I have practiced labor and employment law for a number of years now with Holland & Hart, and one of the issues that we deal with on a regular basis, and we're sure that you deal with as well, are managing leaves and accommodation issues. So this, we know, is fertile ground for issues and sometimes difficult issues with employees. Megan Holstein, who I've known for a number of years now and had the pleasure of working with for a number of years, is the Vice President of Compliance at the Reed Group, and I'm going to let Megan give a short summary of what the Reed Group is and does.
Thanks, Mark. Reed Group is a third-party administrator for disability, leave, and accommodation. So we handle short-term, long-term disability, FMLA, and state leave of absence, and ADA accommodation through outsourcing and software.
Great. Thanks, Megan. So I'm going to go over real quick our agenda that we have for you today. We are going to be talking about pregnancy accommodations, and we will be talking a little bit about some state-specific law with respect to that, but really our discussion on pregnancy accommodation and all of the other topics today, I believe, apply regardless of what jurisdiction you're in, at least in terms of overall application and how it might apply. The state law may be slightly different here or there, but in terms of general guidelines, we're trying to keep this general enough that it's hopefully going to be helpful to everyone, both inside and outside Colorado. We will also be talking about tips for limiting FMLA abuse, handling the interactive process for disability accommodations, talking about what to do when the FMLA ends and the ADA begins. In other words, if FMLA leave has been exhausted, how to coordinate that with employees' rights under the Americans with Disabilities Act. And then finally, we'll be talking about some medical marijuana considerations given the new developments in that area of the law.
And just to add one quick other housekeeping item, we will make the slides available afterwards. We'll send out an email with a link to the slides.
Great. So before we actually get started in the substance, we have just a humorous slide here. Pregnancy, it's all in the accommodation, or I'm sorry, it's all in the perspective. With your baby is the only person in this office who doesn't annoy me, so I'm awarding him Employee of the Month. It really is all in the perspective on some of these issues, and I think that will come through as we talk about this further. And from there, I'm going to turn it over to Megan.
Great. Yeah, no webinar on leave and accommodation would be complete without talking about the pregnant employee, which is one of the most common situations we see at Reed Group, both for leave and now given the state laws that are passing for workplace accommodation as well. There's many laws that govern the pregnant employee. For this webinar, we're going to focus on leave and accommodation rather than anti-discrimination like the Pregnancy Discrimination Act. So, under the FMLA at the federal level, the pregnant employee is covered both under the employee's serious health condition, where pregnancy-related conditions and leave related to checkup visits, as well as any leave necessitated by a pregnancy disability would be covered. But then her bonding time is going to be covered as well after she gives birth and she's recovered from childbirth. Any remaining time off that she might have under her FMLA bank would be covered for bonding leave. And of course, the pregnant employee would still need to meet the eligibility obligations under the FMLA, worked for the employer for 12 months and 1,250 hours. Here in a moment, I will show you states that have similar laws to the federal FMLA that would cover the pregnant employee's need for leave, either when she's pregnant or for bonding, recovery from childbirth as well. One thing to point out under federal law is that pregnancy itself is not considered a disability under the Americans with Disabilities Act. However, some disability condition from her pregnancy may be considered a disability. So if she has an impairment such as gestational diabetes, preeclampsia, maybe needing bed rest, then you may need to consider that condition as a disability under the ADA, engage in the interactive process to see if there's an at-work accommodation or time off might be needed. So we'll talk about the interactive process here shortly. So keep that in mind at the federal level when it comes to pregnancy and accommodation. So what I have next are a series of slides that show you the various state laws that will cover pregnancy accommodation and leave. So first, we have state laws that are, more and more states are passing laws governing at-work accommodations for the pregnant employee, so she may not necessarily need to have a disability as a result from her pregnancy, just the fact that she is pregnant. These states may require accommodations such as the ability to, eat at her desk or take frequent bathroom breaks. And leave may be a consideration as well if she's got severe morning sickness or, as I mentioned, bed rest.
And Megan, I see that we have a question about whether FMLA can be intermittent for pregnancy leave.
I would say yes, because the only condition on intermittent leave is usually governing bonding, where an employer does not have to grant bonding leave intermittently, although they could if they wanted to. But because a pregnancy disability is under the employee serious health condition portion of the FMLA, an employer would have to grant intermittent or reduced schedule leave in addition to continuous.
Thank you. And we've seen the same thing from our end dealing with clients. It's important to keep in mind exactly what Megan pointed out. The bonding time really is not intermittent leave, but don't be too black and white on the pregnancy issue, because there could be a disabling condition or impairment that is a serious health condition that requires intermittent leave, and it just so happens to be related to the pregnancy. So that is something good to keep in mind and a good question.
So the next chart shows states with pregnancy disability leave, and this would also include the time post-childbirth, so recovering from childbirth. These states have a lot in common with the FMLA because they have defined parameters, but the leave reason is strictly pregnancy disability leave. What you'll see with the reason I've sort of charted out these pregnancy laws separately, a lot of them were passed together at different times, and so trends in laws tend to change. So these pregnancy disability laws have been on the books longer than the laws shown in the previous slide, which are more current pregnancy accommodation laws, where they've added the at-work accommodation portion in addition to leave. This next slide is just a quick overview of anti-discrimination laws. So as you can see, most states have in their anti-discrimination law pregnancy, so you don't want to make an employment decision based on the fact that somebody is pregnant or could be pregnant. But that's not necessarily what we're covering in this webinar, but I felt I had to show you those states and those laws as well. And then the final map that we have here are states with FML-like laws. So here they would have the same leave reasons or similar, where pregnancy disability would be covered under employee series health condition, and then there might be a bonding leave reason as well. Or for instance, in California, CFRA, the California Family Rights Act, only covers the bonding, and they have a separate state law for pregnancy disability leave. You know, I'm seeing the bonding leave carved out separately as sort of the leave of the future. We're seeing more at a local level, a lot of paid parental leave, and that, of course, covers both the female and the male employee. So, you know, in addition to these pregnancy laws, when it comes to time off for bonding, you're going to want to start considering those as well. But that's a whole other webinar, I think.
And I see that more questions are coming in. Please continue to submit them. We may not respond to your question as soon as it comes in because we may be addressing that topic a little bit later in the webinar, but please do keep submitting them, and we will respond to those. We may save some for the end as well, but we very much appreciate the questions. And for those who are signing on a little bit late, we will be sending out the slides after the presentation, or providing a link so that folks can get a copy.
Great. The next 5 or 6 slides are really just, again, categorizing these laws and giving you the citations. You know, since you're getting CLE credit, we want to make sure you have some tools and information on the actual laws. So I'm not going to go over them, but I wanted to make sure that you have them, so when we send out the slides, you can see the categories of laws that cover the pregnant employee, whether it's her time off or her workplace accommodation, and you have the legal citation as well. But now I'll pass it on to talk as an example of an accommodation law about Colorado's new pregnancy accommodation law.
Thank you, Megan. And hi, everyone. Steve Gutierrez with Holland & Hart. As Mark suggested at the outset, while this is a state-specific law, the principles that are addressed in the law are applicable in almost every state. Colorado joined the ranks of states that passed a pregnancy accommodation law that became effective in August of 2016. That particular law requires that an employer engage in the interactive process and provide reasonable accommodation to employees who are pregnant, similar to the interactive process, if you will, that is required under the Americans with Disabilities Act. It also mandated certain notice requirements. Now, what Colorado did, like many states, is to amend its Anti-Discrimination Act to specifically provide for the accommodation and the requirements for accommodation, and gave a series of examples in the notice that can be found on the website of the Colorado Department of Labor regulatory agency site. And so what's listed on this slide are the many examples of accommodation that are appropriate, including providing frequent or longer breaks, modifying equipment and or seating, transferring employees to less strenuous or hazardous positions if available, with a return to their current position after pregnancy. On that particular point, I think it's fair to raise that this is probably one of the more common areas of accommodation that we are asked to address, and that is moving someone who's pregnant to a less strenuous position. And whether or not that's a reasonable accommodation depends on a variety of factors, which I'll go over shortly. Other forms of reasonable accommodation, job restructuring, physical limitations that you would recognize, providing someone with assistance or even modified work schedules. So if you do a lot of work in the ADA accommodation context, you'll obviously recognize some of the overlap there with respect to accommodation. Now, I mentioned that in Colorado, a reasonable accommodation must not pose an undue hardship on the employer, and what we typically look to, like the ADA, would be consideration of factors. Now, those factors are going to be unique and fact-specific to the type of accommodation request, and that's why it is important to engage in the interactive process. But we look to the nature and cost of the accommodation, obviously the financial resources of an employer, size of the employer, and the accommodation's impact on the expenses and or resources for the employer. I too also would point out that you could look to the impact that the accommodation might have on the employer, the customer of the employer, in a safety context. For instance, in the healthcare industry, accommodating a pregnant nurse who, as part of their essential job duties, it may require that they be able to lift a patient, and that can be a safety issue, so that you might not be able to engage in accommodation. But we would look to whether or not there's a way to either provide someone working alongside that nurse who could assist, or alternatively moving them out of that position. So that's an overview of Colorado's new law on pregnancy accommodation. Now, there are a number of tough accommodation issues that are going to arise. And again, I said that you have to look specifically to the facts of your circumstance, and difficult pregnancy accommodation decisions can involve leave. You can't force a pregnant employee to take leave that is not requested. And remember, we want to treat pregnant employees similar to those non-pregnant employees. And additionally, recognize that if you have a light duty policy, you must offer on an equal basis as other non-pregnant employees under Colorado law and under the interactive process.
Thanks, Steve. There's actually a couple of questions that have come in that that pertain to what you just talked about, and one of them is with regard to this new law. Does the accommodation have to be requested by the employee?
I think this is always a difficult question, and the answer, in my view, is it does not need to be specifically requested by the employee. If you're on notice that there's the potential for need to accommodate the employee, I think the interactive process is designed to ferret out exactly what the request the employee has with respect to their condition and what potential types of accommodation are necessary, hence why they call it an interactive process. I think if the employer is on notice that there may be a need for accommodation, it's going to be incumbent on the employer to reach out to the employee and engage in that process and try to come to an understanding of what that request is.
Thank you. And another question that came in is whether the accommodation can run concurrently with intermittent FMLA if it reduces the employee's schedule. And I think the answer is yes. And, there's a couple other similar questions to that, which is, I'm going to combine these two questions. Basically, can we transfer someone to a less strenuous or less dangerous position, for example, if we have concerns as an employer about not necessarily the pregnant mother, but the fetus? And that's a really sensitive area. You have to be very, very careful with that, because employers have gotten in trouble under Title VII for discrimination by basically forcing a transfer of a pregnant employer, not allowing a pregnant employee to work some particular jobs out of concern for the potential impact on the unborn baby's health. So I would say be cautious, and Steve and Megan, if you want to add into that, I'd say my view is be cautious before doing that, even though your heart may be in the right place. Be sure legally you're on solid ground.
I think that's the best advice here, is that the no good deed goes unpunished context. Certainly under Colorado law, the Act does not, it prohibits requiring an employee to accept an accommodation that the employee has not requested, or requiring accommodation that is unnecessary for the applicant or employee. I say applicant because the law applies to applicants as well, but unnecessary for the employee to perform the essential functions of the job. So I think that the question raises the issue of whether concern for the fetus and the potential accommodation is necessary to allow the employee to perform the essential functions. So again, I would advise that we really consider our motivation, and while our heart may be in the right place, certainly you got to be careful not to run afoul of the law. Megan?
I think the last thing I would add, I'm of course in agreement, and we'll talk about this under FMLA abuse, but consider using certification in ADA form to get some information from the healthcare provider. It could prompt a discussion between the employee and her provider, but it'll also give you information so that when you do seek your legal advice to see if you can provide a certain accommodation, or if you want to address a certain accommodation that you as the employer think might be needed, you've got information from the employee's provider to add to the interactive process discussion.
Great. Thank you. And I'm going to turn it over again to Megan to talk about lactation laws.
So quickly here, you know, you've got your pregnant employee. She's been accommodated. She's had leave. She's recovered from childbirth. She's bonded with the new baby, and she's back at work. And she's not pregnant anymore, but there are still additional laws, like lactation laws, that you want to consider, because it's likely that she'll need the accommodation to express milk in the workplace. And both federal and most likely state law is going to cover you here too. So under federal law, added to the Affordable Care Act several years ago was the employer's obligation to provide reasonable unpaid breaks for the year following childbirth so that she can express milk. This is actually found in the Fair Labor Standards Act, even though it was part of the Affordable Care Act initiation. You know, I know there's been a lot of talk about repealing the Affordable Care Act. You know, would this lactation provision go with it? Who knows, but it's, you know, just if it is repealed, you still have to address it, lactation accommodation, under state law. And nearly every state that I know of has such a law. And for instance, here's Colorado Nursing Mothers Law. And so not only do you have to give the unpaid breaks, but you have to give a space as well that's a private room and is not a toilet stall. So it needs to be a private room where she can express her milk. So keep that in mind, that even when your pregnant employee returns from work, her accommodations are over, there's one more step, the year following birth. All right. So whether your employee is pregnant or not, we're now going to move on to other FMLA and disability issues. So the first one we'll talk about is how to limit FMLA abuse, you know, whether her leave reason is pregnancy or there's another employee condition, family member leave reason, things like that. So an employee's absence under FMLA often raises question about how to deal with reducing abuse or abusing the time off request. So at Regroup, one of the things we really emphasize with especially our outsourcing business, is using medical certification. So I brought this up already under the pregnancy accommodation question, but it can really be a tool both in making sure you're administering your leave properly, but it also helps you prevent overuse of FMLA leave and abuse. So make sure that you're not only using the certification, but that you're really reviewing it to make sure you have a complete certification and that it's legible. So if you can't read it, you can, of course, contact the healthcare provider to make sure, or to authenticate it and clarify the handwriting. If there's information that's vague or you're missing pieces of information like the frequency and duration, you can follow the clarification process under the regulations and put in writing the missing information, give it to the employee, to give to his or her healthcare provider to get the pieces of information that you need to properly administer the leave. So for instance, if you see that the provider wrote down, leave as needed, that's specifically addressed under the FMLA regs that as a reason to clarify, because that is considered vague. And you can get an estimated time off, especially when it's intermittent leave. You might want more details around the anticipated frequency and duration of the need for leave. If you have vague information about the medical condition, you can seek clarification to make sure the employee is not just seeking time off for a common ailment such as the cold. So just make sure, while you may be hesitant to get diagnosis, you can certainly ask some more questions about the condition, and that's allowed under FMLA. And then there's a recent case, this Bento case. It's kind of a new novel case from a court that we've recently seen that really highlights the use of, or really highlights how courts are supporting employers in using certifications and reviewing them. So in this case, the employer noticed that the employee's primary care physician filled out the form, but that she was actually being treated for her mental health condition by a psychiatrist. So the employer said, well, I want that provider to fill out the form, and when she was returning to work, they wanted that provider, the psychiatrist, to fill out the fitness for duty certification, not the primary care physician who wasn't really the specialist treating the actual condition. And the court supported that. So again, it really highlights the need to review the paperwork, and if you see that you're not getting the complete picture, you really can use the clarification and authentication regulations to your advantage as a way to reduce FMLA abuse. And
let me just tell you a question that came in, because it kind of goes along with this a little bit. If a medical provider says that an employee should miss up to 48 hours in a week or more than what the employee is scheduled, can the employer question why it would be more than 40 hours?
Yes, I think any time you have a question as to what was written, you absolutely can clarify, and just make sure you're following the regulations and you're putting it in writing and giving it to the employee. You don't want to reach out to the provider unless you've received authorization from the employee to do so. The only time you really can reach out to the provider's office is if you're trying to authenticate that the provider actually completed the form. Or if it's something simple like just checking handwriting, is that a 4 or a 9? You can ask a simple question like that.
Thank you.
Mm-hmm. So another useful tool is using the FMLA recertification regulations. I've listed the reasons an employer can recertify here, but the main ones I think to focus on for FMLA abuse are the last 2 bullets. So if you have a reason to doubt the validity of the reason for leave itself, or if circumstances seem to have significantly changed. So if you have an employee, who's out, but then they're sending around a YouTube video of their day in the mountains on a ATV, and they're bouncing around, but you happen to know that they're out because of a bad back, you can seek recertification. You can include a link to the video or a snapshot of the Facebook page to say, is this really something that the employee needs to seek leave for? Is this what the employee should be doing for their serious health condition, things like that. We see a lot of social media issues come up where people are doing possibly something that they shouldn't be doing under FMLA leave. Now, sometimes you're going to get a provider who says, yes, that's an okay use of time off from work with their serious health condition. But it is worth asking, and at least let the employee know that you're monitoring without, of course, harassing them. And then if circumstances significantly change, so perhaps the provider said they're going to need time off 3 times a month due to their condition, but all of a sudden the employee starts requesting time off 4 times, 5 times a month or more, then you can use recertification to get updated parameters of an intermittent leave request. There isn't really any guidance that I've found that says what, or that really describes significantly. So the regs say if circumstances significantly change. I'm sure Mark or Steve are willing to litigate this issue for you if you want to get some more court opinions on what that is. But it's sort of up in the air as to what the word significant means under the FMLA.
Thanks, Megan. I'm going to talk about a recent case, Sharif versus United Airlines. It's along the lines of FMLA abuse and what you can really do, in those situations. In this particular case, Mr. Sharif and his wife both worked for United Airlines. They had planned together a very long vacation of about a month abroad, and he was able to find coverage for his work shifts for that entire period, with the exception of one shift. So he had one work shift that he couldn't cover. And what happened is that Mr. Sharif, who also had a certification for intermittent FMLA leave, called in the day of that one shift and claimed that he needed that day off as FMLA leave, even though he was in, I believe at that time, South Africa, when he called in. And so when he came back, United Airlines investigated, and they spoke to Mr. Sharif, who gave conflicting and inconsistent explanations for why he had called in using FMLA leave, initially saying that he didn't even think he was scheduled for work, which of course led to the question of why he then asked to use FMLA leave, then saying that he couldn't find a flight out and back in time, even though he clearly had no intention of returning to Washington, D.C. for that one-day shift. They went on as part of their trip to visit with family in Italy right after that. And ultimately, United Airlines terminated Mr. Sharif for dishonesty. And I will tell you, having litigated these types of claims, those are always touchy and difficult issues for an employer, because you never quite know, even if you're on solid ground, whether the employee is going to challenge it and where it will go. And in this case, the employee did challenge it and claimed that he wasn't terminated for dishonesty. Instead, he was terminated in retaliation for exercising his FMLA rights by calling in on that one particular day. And ultimately, the Fourth Circuit, so this went to the trial court. The trial court said, no, this is not a viable claim. You don't have any evidence to support it, so we're not even going to let it go to a jury. The employee appealed it up to the Fourth Circuit Court of Appeals, and the Fourth Circuit Court of Appeals agreed with the district court and said there really is no viable claim here. There's no evidence that United Airlines had any retaliatory intent here, and that's really in large part because they conducted a good investigation. They documented it, and it was, you know, one of those unusual circumstances where it just looked bad on its face. It just looked like he was playing the system. But the word of caution and advice that I would give, having litigated these issues, is just because something looks bad and you may believe, and you may be right, that an employee is lying or abusing FMLA leave, do your investigation, dot your I's, cross your T's before you take disciplinary action against an employee. And I know we had a couple of questions on certifications, so before we get too far from that, I wanted to just go over a couple of those. One was whether the, sorry, I'm scrolling back. We've had a number of questions about these. Can a medical certification have both an intermittent and continuous on the same certification?
Sure, yeah, assuming the dates are different, because often somebody's going to go out maybe for surgery, but then if the condition is expected to flare up, or if they can't work when they're still recovering, or that maybe they're going to work part-time for a different time period, you could see that.
And I think this is a clarification on what you were also talking about, Megan, on the physician who can complete the form. We have a question as to whether the employer can request the medical certification form be completed by a treating physician and not the primary physician.
That's precisely what that case was addressing. So yes, in that jurisdiction at least, you'll want to read that case.
Got it. And then another question is what if there is a medical certification for intermittent leave for 4 consecutive days, 4 times a month, and the FMLA leave covers 12 months, and the employee is not taking all that time off or has not taken all that time off? Can you ask for a new medical certification?
So to me, that's a recertification. Things appear to have significantly changed than what the provider addressed in the initial certification. That's my initial instinct to that question.
Okay. There's another question about certifications for the ADA or recertifications for the ADA. Are they similar to an FMLA recertification? I'll defer to Megan and Steve on that a little bit. My own question about that question is just ADA doesn't necessarily require a recertification per se in the same way that the FMLA does, which is prescribed through the regulations. You may have similar questions for both if you're looking at an ADA leave either concurrent with or after an FMLA certification, where you're asking very similar questions, but I wouldn't suggest simply using the FMLA form in the context of an ADA interactive process.
Yeah, I think the ADA wants the employer to check in with the employee to make sure the accommodation is working. So if you do see that things have changed or maybe there's a different accommodation, you should consider that, and whether you want to call that a quote-unquote recertification, I would just say it's part of your ADA obligation to check with the employee and continue the interactive process.
Right. So why don't we're continuing to review your questions. Keep sending them in. They're great questions, and we're going to continue through, and we will continue to get to your questions either throughout the presentation or we'll save a little time at the end as well. So
the last case that I found interesting from last year that I just wanted to touch upon, you know, as you're getting certification and information, sort of be careful what you do with it and make sure you remember your record-keeping obligations under the FMLA. This is a case that was filed. We don't have a decision yet, but the employer became aware that the employee was using medical marijuana, and it was somehow listed on the FMLA certification. They made the employee take a drug test. It actually came back negative, but they required the employee to resign or be terminated due to this medical marijuana use. The employee actually sued the provider, not the employer, but, you know, I just want to point out that, you know, at Regroup we see all kinds of information on our certification forms, but be careful what you do with it, and when you're doing an investigation and you're looking at information, if you have question whether you can take action, you definitely want to consult your legal counsel.
And before we jump into the interactive process, one other question I wanted to address now was a question about posting. If someone posts something on social media and claims it's a different time period, what can you do? And I think the question is if you see evidence in social media that may be different from the certification or may throw into doubt whether the person is really on FMLA leave, I've run into that. I'm sure many others have as well. I would investigate it and talk to the employee. I've actually had a case in court where the employer did not investigate what appeared to be abuse at the time, later fired the employee for other reasons. I really think that employee was lying about her FMLA leave because they had some pretty good social media posts that showed it, but because it wasn't investigated at the time, we had kind of let that ship sail. So I'd take a look at it when it happens and look into it just as you would any other potential abuse. So jumping into the interactive process. The interactive process, I think as Steve mentioned and as we talked about, whether you're talking about pregnancy accommodations or accommodations under the ADA or Americans with Disabilities Act or a state counterpart to the Americans with Disabilities Act, really follows a fairly set pattern, or at least it can and should, which is you want to discuss the issue with the employee. You want to evaluate what really are the essential job functions, and you want to identify the limitations or the restrictions at issue. I know some people really get concerned because they feel like when we sit down with the employee, we're going to have answers to every question and have to come up with a solution right then and there. That's not the case. It really is interactive, and I recommend keeping it that way. And it should be a give and take, not a one party says this is it and that's the end of it, whether it's the employer or the employee. And so that really goes into this next slide of look at a range of potential accommodations. Really consider and evaluate whether there is an undue hardship. In my view, that's always a tough burden, but it's something you should consider. And talk to the employee about the decision. And the key to all of this is make sure to document it. You really want to document the decision and how you got there, because I have had situations, and again, I'm sure others have as well, where you've gone through the accommodation process and made certain decisions, and the employee may have agreed with it and maybe even said that was the best possible decision. And yet, 3, 4, 5 months down the road, things change and the employee may come back and absolutely disagree. So make sure you confirm in writing with the employee. When I say document, what I mean by that is send a confirming memo or letter or something to the employee, even an email, something where you're sure the employee has seen it, and that will go a long way to avoiding disputes down the road.
Yeah, there are a number of questions that come up in the documentation context, certainly with respect to requiring documentation to establish that a person has a disability. But I want to step back first and pose a question that I've been asked a number of times, which is how much documentation is appropriate? And the answer to that is as much documentation is appropriate is going to be the amount of documentation necessary for you to establish that you've engaged in the interactive process, that you understand the nature of the disability. I often tell folks, though, you need to be careful what you ask for, and you should really consider when requiring documentation to establish that a person has a disability, who you're asking the information, who you're asking to provide the information, and it should come from an appropriate healthcare provider or someone that is, as previously mentioned, giving the care. Now, there are some limitations, and one of them is you can't request documentation for an obvious condition. A disability is obvious if it's already known by the employer or is clearly visible, or the individual previously provided information showing that the condition existed. It is okay to require, again, as I mentioned, that someone document their disability and that the disability necessitates an accommodation. And so what I tend to tell folks is keep that documentation. It's important for the interactive process proof, but we want to make sure that it's separate and confidential from the employment file so that it's on a need-to-know basis.
Steve, what would you recommend if an employer asks an employee to provide medical documentation in connection with this process and the employee just doesn't do it, just doesn't provide the medical documentation?
Well, the way to address that issue, again, is to go back to the employer and explain to the employer, I'm sorry, I used the word employer, go back to the employee, explain to the employee that you need the information, that you're entitled to the information, and that if you don't get the information, you're going to make a decision as to what's appropriate for the accommodation first, and whether or not there is, in fact, a disability based upon the record that exists, and set forth a specific time frame within which to provide that information. If you don't get it, then I think you make a decision based upon the record. I don't know if you have a different view of that, Megan, or not.
No, I definitely agree, and that comes up where we have employees who don't want to give us information, and we try to explain to them, you know, we're not trying to dig into your medical information. What we're just looking for is information on the disability only, no other health information. And also what we're getting at is really how the disability limits the person from doing the essential functions. So what's the impairment? And hopefully by explaining that's the reason to get some information so we can figure out what's preventing the employee from doing the essential functions in order to come up with the right accommodation. Sometimes that alleviates the employee's concern.
Yeah, I think that's spot on. One of the important things, and we'll go to the next slide, about written documentation is that it also helps provide us the evidence necessary to determine, if we determine that the accommodation constitutes an undue hardship, the burden is going to be on the employer to prove that. Obviously, under the ADA, we're not required to provide a reasonable accommodation that will result in an undue hardship. And earlier we said that some of the principles of state law sort of overlap with the federal law. And when I talked about reasonable accommodation in the context of the Colorado Pregnancy Discrimination Amendments, the undue hardship construct is the same. And so when you're looking at whether an accommodation is an undue hardship, remember, expense by and of itself is not a definitive determination. But those factors I mentioned earlier, the nature and the cost of the accommodation, the resources of the company overall as compared to the accommodation, and the specific location, the number of employees at the company and the location and the impact of the accommodation on the overall operation are all important factors. Again, the caveat is these are very fact-specific inquiries, and so what may be an undue hardship for one employer could not be an undue hardship for another if the overall financial resources of the business are completely different. So be aware of that. The next component of it is to talk about direct threat and factors that should be considered when analyzing that there's no direct threat. An employer may exclude individuals who pose a direct threat to the health and safety of themselves or others. Comes up quite a lot in certain industries, but it requires a significant risk of substantial harm. Again, we've said earlier that you cannot base a decision out of your own fear, your own assumptions, and if the threat can be eliminated through a reasonable accommodation, then we must accommodate. So there are some factors that are important here: the duration of the risk, the nature and severity of the potential harm, the likelihood of the potential harm will occur, and the imminence of the potential harm, all important factors to determine whether or not the direct threat component applies.
All right, so I'm going to move on to how to respond to an accommodation request, and obviously we've talked a little bit about this already. A couple of questions that have come in really deal with this very issue, which is, well, what if you have a third party that's helping address accommodation, like such as the REIT group? And I'll definitely want to get Megan's input on this, but the couple of questions that came in as well, you know, what if you have a so-called obvious disability, but either the department that's dealing with this is separate and apart, or it's being handled by a third party and it's not obvious to the third party because they're not there? From my standpoint, again, Megan, please weigh in. Ultimately, it's the employer's obligation, and if the employer has information that this is an obvious disability or an obvious impairment, that information should be communicated to either the department or the third-party entity that's helping to track or handle these accommodation requests. Would you agree with that?
Yes, so we have that either a client's HR department calls us and tells us, the employee tells us on what we call intake when we're initially talking to them. They explain the condition, and if it's very clear, you know, I'm in a wheelchair or something like that. But our accommodation form also asks that question of the provider, and then we ask them to skip certain questions and just get down to the needed accommodation question. So we skip anything having to do with the disability analysis because it is open and obvious. So we address it in various ways.
Right. And that's something to be careful about if you're working with a third-party provider. Just make sure you understand that I think it's great working with a third-party provider, but that doesn't mean you're not still responsible for ultimately accommodating that employee and making sure to communicate with them, or that the communication is happening appropriately. So just keep that in mind. And a couple keys to making the interactive process and accommodation process successful are being as prompt as you can. That doesn't mean you should feel like you have to make a decision right on the spot or in an hour, but keep things moving along. Making sure you are staying interactive, and if you're rejecting an employee's request, you're thinking about other options that may work. Making sure to keep medical information confidential. I can't tell you how many cases I've seen where that one issue has been a huge driver for a lawsuit because someone believes that the employer, the supervisor, typically shared information that shouldn't have been shared with coworkers. And even though that wasn't even necessarily a violation, there didn't happen, it still can be a real problem. So be careful with that. Be patient and make sure, you know, that you're doing your best to respond promptly, but make sure you communicate regularly with the employee so that the employee knows to be patient as well. And again, document. And another question that came in was whether you can simply rely on the documentation that comes in the context of an application for short-term or maybe even long-term disability. I'd say be careful about that. You don't necessarily have to have separate documentation if you have enough information that suggests the person, you know, is entitled to a leave. And a lot of times those applications do address different issues, but be careful on forcing employees to create documentation themselves where there may not necessarily be a need. The big issue is making sure when we say document that you're documenting the process with the employee that you followed. Now moving on to the FMLA and ADA, this is a difficult ground for, I think, a lot of folks. I will tell you the EEOC is very focused on the overlap between the FMLA and the ADA, and I will talk about that more specifically in a bit, but I will tell you from personal experience, this is definitely a high priority issue and area for the Equal Employment Opportunity Commission. There's definitely some overlap with respect to the FMLA and the ADA. Both may involve reassignment to a degree. Under the ADA, it could just be as an accommodation. Under the FMLA, it may be necessary based on an intermittent or reduced schedule. Light duty may also be an accommodation under the ADA, but under the FMLA, you really shouldn't be forcing a light duty if the employee hasn't exhausted the FMLA leave entitlement, because FMLA is leave. That's really what the FMLA is. The ADA is broader than that. The ADA could be leave of absence, it could be light duty, it could be both. So just keep in mind that there is some overlap here, but they're not identical. And whenever you have someone who's out on FMLA leave, I would think about, does this raise an ADA issue, and vice versa. If you have someone asking for an accommodation under the ADA, consider whether this implicates the FMLA or any local or state counterparts to the FMLA. So with respect to leave as well, obviously leave must be provided to eligible employees under the FMLA if they meet the requirements. Under the ADA, leave can be a reasonable accommodation, and in my experience, it often is at least part of the accommodation process. The big issue, and this is what I was mentioning earlier, that the EEOC is focused on. When FMLA ends, what do? I can't tell you how many companies have gotten into trouble by just firing employees when they exhaust their FMLA leave. And if you do that, if you have a policy that says that, I highly recommend changing it quickly, because the FMLA or the EEOC is all over this issue. They have developed good case law, and the way really to handle this is before the employee exhausts the FMLA leave entitlement, reach out to the employee, preferably in writing, and say, as you know, you are about to exhaust your FMLA leave, or you are scheduled to return to work as of X date. We just wanted to make sure that that's still the schedule and that's still the plan. If anything has changed, or if you need any modifications to your work or additional leave, please contact us. Please reach out to us. And that way you are complying with your duty to engage in the interactive process. You will address potential issues under the ADA, and you will avoid what can turn into a very difficult fight with the EEOC. Obviously, if there is no disability and the person says, I just want another month, I'm not ready to come back to work, then there's really no job protection there unless the person can claim they're regarded as disabled, or there's some state or local law or some policy that provides them with that protection. But the problem is you may not always know whether they're disabled or not. And so it's a good practice to have in place. One of the questions is, and a question that's being asked today is, well, what's a reasonable time limit for leave as an accommodation? And that's a great question, and I wish I had a solid answer for you. Some courts have said, hey, listen, by the time you get to more than 6 months out, that may be too much, but it really depends on your leave policies, what you've done in the past, and it's going to be a very fact-specific inquiry. Because if you have allowed people 6 or 8 months leave of absence for other reasons, that could very well be a reasonable accommodation. And generally speaking, if you have a reasonable accommodation under the ADA, a question that's come up is, does that mean that that doesn't start until the FMLA is exhausted? Kind of. I mean, that's if they're entitled to FMLA leave, they're really not triggering a need for a reasonable accommodation under the ADA at that point because they are covered by the FMLA. But once the FMLA leave is exhausted, they may still be entitled to leave under the ADA at that time.
Well, and I'll chime in here that the EEOC commissioners don't necessarily have a solid answer on that. They will disagree as to whether your obligations under the ADA, you're on notice when somebody asks for FMLA. I've had Commissioner Feldblum answer that question with, yep, the minute you know FMLA is triggered, start thinking about ADA, and the clock starts running. Commissioner Lipnick is, you know, she comes kind of more from a DOL perspective and understands the FMLA. I think that applies first. So don't forget about the ADA just because you're working through the FMLA, really is what I think I would say about that.
Yeah, absolutely. They both could apply, but also the other thing I would add is if you're counting time for reasonable accommodation and the person had leave available under the FMLA, I'd be very cautious about saying, well, we've already accommodated you under the ADA by giving you 12 weeks of leave.
But you can count the 12 weeks towards the ultimate amount of time.
Exactly. That's exactly right. So it's I know this sounds a little bit gray. You can certainly look at it, but what the bottom line, and hopefully this simplifies it, is don't say to an employee, we've already given you 12 weeks of leave under the FMLA, and so you're not entitled to more. That's really the bottom line takeaway. You can look at the total amount and say you've already been gone 12 weeks, and now you're asking for an additional 6 months, and so that's, you know, we're going to look at all of that together. That's fine to look at that together to determine whether it's really reasonable. So obviously we talked about this issue of when FMLA ends. The example we have here is someone who has cancer and needs 12 weeks off under the FMLA, and then they come back and they, or they can't come back and they need an additional month. That may very well be a reasonable accommodation. The next issue is the more difficult one, and the one that I run into more often, which is the return to work date continues to be pushed back. How much is enough? I'd be real careful with this one. This is where I see a lot of employers getting either sued or getting a charge of discrimination when someone says, hey, I need an additional two to 3 weeks and then I'll have more information, and the employer says, no, you've already been gone too long, we've got to move on. What I will say is the case law out there has said a request for an indefinite leave of absence is not a reasonable accommodation. But if someone is telling you, hey, I will have more information about when I can return, I just need an additional 2 to 3 weeks to get that worked out, I'd be very cautious about not giving them the additional 2 or 3 weeks. Megan and Steve, I don't know if you have a different view of that, but I've seen a number of employers have trouble with that piece of it.
No, there's absolutely a problem here for a number of clients. I do think that there is going to be a time where most of the employers out there are going to say we've had enough, and there is no reasonable basis to believe that the employee is coming back soon. The importance of making that decision is going to be dependent largely on the facts of your case, and you should have a reasonable articulable basis to have concluded that the leave is nothing more than a request for indefinite leave before you take adverse action against the employee. Megan?
I think this is, again, where your documentation and certification is important. You should, upon an extension request, especially if it's maybe a second or third extension request, you need to ask the provider, what is it about the time off that is going to enable the employee to get back to work? Are they adjusting the medication? Is the healing process just taking a little bit longer, but you anticipate a full, you know, the body part is fully going to heal? You want to pinpoint that down, because if the provider cannot articulate that the time off is going to help the employee get back to work, then you're looking, in my opinion, at an indefinite leave.
You know, and someone on the webinar made a great point. We've been talking about combining the time frame for FMLA leave when talking about a reasonable accommodation under the ADA, and we've been talking about that in the sense of the person took FMLA leave for their own serious health condition. If someone took FMLA leave to care for a family member, for example, and then has their own serious health condition, I would not count that FMLA leave against them for purposes of talking about accommodating them under the ADA, because those are two separate issues. And another clarification question is, if someone needs additional time to recover from a surgery, but it's not a disability, do you still cover that under the ADA? If it's not a disability under the ADA, they have no right to an accommodation. But again, if someone has a surgery and you're not quite sure whether that really is going to be a disability or not, I'd be careful about just firing them because they could potentially argue that you regarded them as disabled and that's why you fired them. So just be cautious. When the law changed back in 2008, the idea under the ADA as amended was that employers wouldn't get so overly focused on whether someone is disabled or not, but instead would focus on, can we accommodate this person? And if you focus more on that, you will be better served. And now moving on to marijuana.
So our last topic, which is near and dear to those of us here in Colorado, because we've seen both medical and recreational marijuana laws get passed here, and I'm sure the three of us have all dealt with them in the employment scenario. And after the election in November, there are more and more states that are faced with the questions that we have here in Colorado. So as you're working through accommodations, and then here at Regroup, we deal with disability, short-term and long-term disability, so we tend to see sometimes medical marijuana come up too. I just want to highlight a few things. I know we're running out of time, and Regroup actually put on a webinar and a white paper, which we just updated. You can find on Regroup's website for more information. But keep in mind, marijuana is still illegal under federal law. So, you know, you got to keep that in mind, especially if you as the employer are subject to certain federal laws like Department of Transportation laws and things like that. However, after the election, you're seeing more and more states with some form of marijuana law, medical or recreational, and of course that's going to impact your employees and what you do and whether you have to accommodate, especially the medical marijuana use. So some of these laws have something in their medical marijuana law that says you as an employer cannot discriminate against legal users. So this is basically saying you can't make a decision, an employment decision, just because the person is a registered medical marijuana card holder. In a few of the states, you can't necessarily make a decision just because they failed the drug test. You may have to have some additional considerations before you make an employment decision. So for instance, here, Nevada has the strictest language for you employers. You really want to move slowly if you find that the employee is using medical marijuana or failed a drug test. You may have to reasonably accommodate the medical need. Now, keep in mind, nowhere am I suggesting, and none of the state laws require an employer to accommodate on-duty medical marijuana use or recreational use, or accommodate impairment at work. So that is never going to be an accommodation you will have to deal with under any state law. If you're in New York, the fact that somebody is a medical marijuana card holder, they're deemed a certified patient under their disability law, so your state disability requirements and interactive process may kick in, but not to allow use at work or impairment at work. And here in Colorado, we've litigated medical marijuana use at the workplace all the way up to the Supreme Court. So
Yes, most of the cases in Colorado of medical marijuana have been in whether you have the right to terminate someone and whether someone's use of medical marijuana can be a disqualifying event under the state's unemployment law. We've also had a very recent case, Curry versus Miller Coors Incorporated, which arose in the context of a discrimination claim. In that case, the plaintiff, who suffered from Hep C and osteoarthritis and pain, used medical marijuana as a method to manage the symptoms of his disabling condition. He claimed that he never used marijuana on his employer's premises and was never under the influence of marijuana, which is a issue of much debated issue in Colorado, what constitutes being under the influence, but I'll leave that for a different day. In any event, he was fired for testing positive for marijuana in violation of the company's written drug policy. Like most discrimination cases, the issue of discrimination depends a lot on proof of motive. In this particular case, the federal court found that it was appropriate that an employer who has a lawful drug-free workplace policy and terminated someone under that policy for testing positive is a legitimate reason, and the state's anti-discrimination law doesn't extend to shield a disabled employee from implementation of the employer's standard policies against employee misconduct. So a good win for an employer in this particular case. And so let me move to the next slide and raise one other issue that is worth mentioning here. And that is many states, like Colorado, prohibit employers from firing employees for off-duty use of lawful product or engaging in other lawful activities. So in Colorado, we have a Colorado lawful off-duty conduct statute. But as I mentioned, at least the Colorado Supreme Court has held that even though it's legal to possess medical marijuana or recreational marijuana, the Supreme Court in Coates versus Dish Network upheld the termination of employee who tested positive for marijuana in a random test, ruling that his off-duty, off-premises use of medical marijuana was not protected under Colorado lawful activities statute, as it is still illegal under federal law.
So the bottom line, as I've said, it's okay to discipline for on-duty or on-premises use, or if they're under the influence while working. It is absolutely okay to have drug-free workplace policy. I think every state agrees with that, and it's okay to drug test. It's just check your state law, your marijuana law, as to what to do if somebody has a positive drug test, because there are a couple states out there, they're outlined in our white paper, as to what you may need to do. But the majority of states are similar to, take a position similar to Colorado.
And that covers what we wanted to cover today. I know there are still some questions that we haven't answered, and we are going to get to those. I'm going to run through those here in just a second, but before I do, I just wanted to say thank you to Megan and to Steve for presenting. Thank all of you for participating in this. And I know we had some additional questions on the PowerPoint and this webinar, and I believe we'll be sending out a link to both a recording of the webinar and this PowerPoint to folks. So you should be getting that within the next few days afterward. So let me run through a few of these questions, and let me just give you the caveat, as we always do, that some of these questions are pretty general and some are very, very specific. Obviously, with respect to specific employees, we always recommend, seek appropriate counsel on those, because we can give you some general responses here, but not legal advice through a webinar or presentation. And some of these I'm going to answer a little generally for that reason. For example, what if an employee doesn't respond with the appropriate paperwork that you have requested after the person exhausted the FMLA? It looks like you've been asking for ADA paperwork. And again, I would want to make sure that you have documented repeated requests and make a decision based on the information you have in front of you. I wouldn't say simply deny the request because it may be that you have enough information without that written documentation to make a decision that grants the request. So look at what you have and make a call on that, and make sure that you have appropriately documented your attempts to get that information. It looks like that's a couple of questions of whether you need to continue ADA leave when the employee fails to provide medical documentation to substantiate the leave. Again, that's really the same issue. It looks like that happened over a period of 3 months. Just be careful that you don't need that additional medical documentation. If you really have it and you've documented it, you're in a better position to say, hey, you haven't given us the information we need to substantiate this, and therefore we're going to deny it. But personally, and Megan and Steve, let me know if you disagree, I would at least do one final notice to the person, if you haven't already, saying, we've asked you on these 3, 4, whatever occasions to provide us this information. We've told you it's necessary for us to evaluate and substantiate your request and your need for this leave. You have not provided it to us, and if you don't provide us with this information, then, we do not have a basis to grant you this leave, and, your leave will be considered, unapproved or unprotected or whatever it is, and you may be subject to disciplinary action up to and including termination, so that it's clear you've told them what the consequences are.
Yeah, I think that's absolutely right. Once you've communicated that, you'll then be in a position to make a legitimate decision based upon the record as it exists. And if there is a violation by way of the employee not being present, obviously that's another legitimate basis to discharge someone. Megan?
Yeah, I think that the courts agree both under FMLA and ADA that the employee has obligations, and one of their main obligations is to return certification or to engage in the interactive process.
There's also been a few questions, and we did touch on this briefly, about, how much time is really a reasonable accommodation? What if people keep saying, I need 2 weeks, I need 3 weeks? They continue to make those requests, and again, it's a very fact-specific inquiry. It doesn't have to be indefinite, as Megan touched on. You don't have to grant an indefinite leave of absence. And if someone repeatedly says, just 2 weeks more, just 3 weeks more, just 2 weeks more, just 3 weeks more, at some point you can say, okay, enough. But again, make sure you've documented it. Make sure that you're on solid footing with your own policies and past practices in terms of the amount of leave that you have provided to others. We've had a couple of questions about finding an accommodation form and a fitness for duty template. I'll defer to Megan. I'm not aware of a particular one-size-fits-all accommodation form. There are forms out there on accommodation requests and how to handle those that kind of lay out the process, so to speak, for different employers. But I'm not aware of a specific form that has been approved by, for example, the EEOC, per se.
Right, yeah, the ADA does not have an appendix, like a suggested form. Regroup has a white paper on leave as an accommodation, so if you go to regroup.com under our resources page, on the white paper we have an interactive process checklist, and we have a form that, a sample form that sort of throws in the kitchen sink. It kind of covers every scenario, including the is it open or obvious disability that we talked about earlier.
Yeah, and I think that is a good resource. I've been on their website, and I would also put in a plug for Holland & Hart's blog our labor and employment blog, employerslawyersblog.com. You can get to it through the website, but and you can subscribe to it, because whenever there are new developments on leave or accommodation issues, we always do our best to make sure to get that information out to folks through the blog. Let's see, here's a question. I think this is for Megan, for you on the recertification issues or certification. When an employer has a third-party administrator, can the employer still request the recertification?
As opposed to the third-party administrator?
I think that's the question.
Well, because I work for Regroup, I would say you should work through your third-party administrator. You don't want to confuse the employee or look like you're harassing the employee under FMLA, that you're interfering with their FMLA rights by requiring both third-party administrator and complying with employer requests. So if we have an employer who maybe gets the Facebook post and wants a recertification or has information that they see in the workplace, we recommend they come through us to say, hey, here's what's happened at work that we've seen. Can you please request a recertification? And if we need to do a specific cover letter to the employee to give to the provider, we'll work with the employer. But I think you want one place of communication rather than both the third-party administrator and the employer, because then they don't know who to communicate with.
Yeah, I agree, and I've run into that issue as well. Keeping consistent communication lines is important. Does Reed Group, in connection with that prior question, does Reed Group have a single resource tracking all state leave laws?
Yes, we do. So we have a tool, leaveadvisor.com, which is the federal and 50-state leave law, but it's also part of our software. So for our software customers and our own service center that handles our outsourcing customers, the state leave laws are all present in our software tracking system, and information is linked from our software to our leave advisor.
Right, and I know there was a question earlier about intermittent leave under local laws or regulations, and it was a good question, and I would just say be aware that when we were talking about intermittent leave under the FMLA and when it may or may not be entitled, make sure you check state and local law as well, based on the jurisdiction you're in, because we couldn't address all of those here, but more and more states and frankly cities are enacting some type of leave laws these days. So,
and Leave Advisor has information on municipal and county laws as well. Great. Who doesn't love all things leave?
That's right. That's right. I think I'm going back through to see, and I hope we didn't miss any. If we do, I apologize. I'm trying to go through all of these just to make sure we got to as many as we could. I think we hit some of these on the recertifications. We talked about the fitness for duty.
Oh, somebody asked about a fitness for duty form. I don't know of a one-size-fits-all fitness for duty. It's definitely going to be specific to the industry or position, I think.
Got it. Okay. I think that, let's see. There's a couple more up here. Let me just see. An employee is out of work due to a work-related injury and the time is running concurrently with FMLA. The third-party administrator receives medical documentation. Is the employer held to the 48 hours time frame to make the determination? I'm not quite sure I understand the question. Give us just a minute with this one.
So under the FMLA, the employer has 5 days to let the employee know if they're eligible once the employer has reason to know of the need for possible FMLA leave. Once the employer has the information, like the certification, they have 5 days to issue an FMLA determination. Work-related injury and time is running concurrently with FMLA. The TPA receives medical documentation. So I'm going to assume your FMLA TPA, because if your workers' comp TPA is different, then your FMLA TPA still doesn't have what they need unless they're working with your workers' comp. So in some cases, employers have the same TPA, a workers' comp and an FMLA, but in other cases, like we will work with the employer's workers' comp provider and exchange information. But you have 5 days, not 48 hours under the FMLA.
Okay. Another question was whether someone on bed rest will fall under the ADA, and I think this was in connection with the pregnancy accommodation. My response is it could. It could fall under the ADA. It could fall under, a state law on pregnancy discrimination. It could fall under federal law. So I would look at whether or not you can accommodate that. Generally speaking, whether it's under the ADA or under a state or other federal law. And then there's another question that's maybe somewhat similar. Even though pregnancy is not by itself considered a disability, would we still consider, I think, leave of absence accommodations due to a disparate impact? And yeah, I mean, if you're singling out pregnancy and saying you can have a leave of absence for all these other things, but not if you're pregnant, then yes, you're going to run into problems with that type of a policy, whether it's disparate impact or, frankly, in my view, that would be a facially discriminatory policy. In that case, not disparate impact is you have a neutral policy that has a disproportionate impact on a particular group. But if you single out pregnant employees, that's going to be a facially discriminatory policy in my view. I think, and I really hope that that covers all of the questions. Oh, there's one more. Is there a time limit for travel time for employees taking time to care for a family member in another country? I'm not aware. If I understand the question, I think the answer is there's not a separate time limit just because the person is out of the country to care for a family member. They're subject to the same FMLA leave requirements as anyone else would be for taking time to care for a family member.
Yeah, if the family member needs 1 week of care, but they're seeking 12 weeks so they can include an around-the-world trip to get to that country, maybe your HR investigation will ferret that out, but there's no limitation that you can only go so many miles to care for a family member.
Yeah, and there's been a request to send the link to access the white paper on marijuana. I think we can do that when we send out the link to this presentation, so we'll do that. There was another question about the time limit an employee should have to return ADA paperwork. There really is no prescribed time limit for that. It's whatever is reasonable. If someone is delaying or not getting you what you need, then continue to follow up, but there is no set time limit. And another question about a template, is there an interactive process template to use while performing the interactive process? Yeah, there's Regroup, Megan was saying, has a checklist. We certainly have reviewed, created, and modified those templates here for employers. You can find some things to work with on the internet, but having looked, I would be very, very careful about just using something you pluck off the internet for that, because I've seen some templates that are fairly good and some that are not. So I would work with someone you trust rather than just plucking that off the internet. You can find maybe a good starting point sometimes on the internet, but there is not a prescribed form to use. All right. Well, thanks again, everyone. We appreciate it. Those were great questions, and we appreciate your participation in this webinar. We hope to do more of these in the future, and we hope everyone has a great day.
Thank you.